I'm Erin Chick, Executive Director of Common Sense Adoption Services. Welcome to our YouTube channel. In this video, I'm going to start a short series on the legal process and what families can expect when they enter foster care and the adoption process. In this video, I specifically want to talk about the legal process for children in foster care. So let's get started. So I think it's important to understand as a foster family or a family who's seeking to adopt from the foster care system that there's a legal process that's going on, often sort of behind the scenes, that you may not really understand all the parts and the players and the process that's occurring. So let's start with talking about what's happening when children enter foster care from a legal standpoint. First, it's important to understand there's a number of key players in the legal process. First, you'll have a judge and sometimes a court master who's hearing all the different court hearings and court processes. That's the group that's going to be overseeing a lot of this. Second, because children in Pennsylvania are coming into a county-run foster care system, Children and Youth Services will be represented by their county solicitor. Next, the birth family, and typically it is the identified birth mother, birth father, and if there are other potentially legal fathers in the picture, they will all be represented by legal counsel. Finally, we have the child. So every child who becomes a dependent of the foster care system will be appointed an attorney who represents the child's interests. And this person or individuals are known as the guardian ad litem. Sometimes we reference the GAL, which just stands for guardian ad litem. That is the attorney assigned for that child. In some cases, counties have a program called CASA, which is the Court-Appointed Special Advocate. So a child may also have a CASA worker, not an attorney, but this is another individual who's assigned to oversee and ensure that the needs and rights of the child are being represented through the process. So they're not an attorney, but they do play a vital role in court. So those are the key players. And if you notice, I didn't mention you, the foster family, and legal counsel for you. Because at this stage in the process, you do not require your own separate counsel. This whole process right now is focused on that child and their family of origin and trying to move them either back home, which is always our first goal, to kin, or if all efforts fail, then looking at an alternative placement for that child long term. So once a child enters care, there's a hearing when they first enter care. It can be a shelter care hearing, which is just to allow the county to take emergency custody. It can be a dependency hearing where a judge is going to decide that that child requires the care and protection of a county children and youth agency, and that child is put into the legal custody of children and youth. That hearing typically occurs within the first week that a child enters care. After that, there are routine review hearings that will occur throughout a child's time in placement. These hearings can happen every 3 to 6 months. They are meant to monitor how a child is progressing in care, how their family is doing in terms of meeting the goals to return that child safely home. So these are status hearings that are checking in to see how everybody's doing. Some of these hearings will be held by a court master. Other ones might be held by a judge. So you can see as a foster family that you may be attending a hearing that it's a court master that's going to be overseeing that hearing. You may attend other hearings as a foster family that a judge is overseeing. At each of these hearings, represented at the hearing will be the county through their solicitor, the family, the birth family, through their attorney or attorneys. The child's guardian will also be there, as well as staff from the County Children and Youth Agency who provide testimony. Our agency as a provider agency will be there to provide testimony. You as the foster parents will need to be there, and the child needs to be present. So foster families have the job of ensuring that children arrive on time and are present during these hearings. Sometimes children will testify, oftentimes behind closed doors, just with the judge. Foster families don't often have an opportunity to testify during hearings because the reports that our agency completes during our routine supervision have already been submitted to the court. And the court's using that to see how is this child doing in care, and are the goals for that child being met. They're going to look at things like, is the child visiting regularly with their birth family? Are they visiting with siblings if they're not placed together? They want to make sure they're up to date on their medicals, dentals, that they're getting therapeutic supports. So they're really looking at the child's overall well-being and adjustment and safety. They're also closely monitoring how is the family, and this is the birth family, doing in terms of achieving the goals. So there's a family service plan that was developed when the children entered care, and the court is monitoring, is the family working towards achieving the goals? And those goals are meant to fix whatever needs to be repaired so that a child can safely return home. So this whole process, from the time a child enters care initially and eventually leaves care, whether they go back to their birth family, they go to live with kin, or maybe are adopted, whether that's by their foster parent or another family, this whole process can take several years. During that time, like I said, there are regular hearings every 3 to 6 months where they are monitoring progress. The goal is not to have children languish in care. That said, typically we don't see a move to change a goal from reunification or return home for at least a year. Every effort will be made to try to get children back to their family of origin. And really it's only when we start to get 12 to 18 months out that a court may start to look at another possibility. It's important to understand too, in terms of the legal process, anytime there's a significant change for a child in care, it's likely there will need to be a hearing. So examples of this would be if we need to move a child. So maybe a child's in a foster home, it's not a good match, or that family is no longer able to provide care to them. We need a court order in order to be able to move that child to another home. If a child requires inpatient treatment somewhere, say a residential treatment program, an inpatient psychiatric program, we have to get a court order, and we being the county, again, the county is the one with legal custody of this child. So the county has to get a court order approving that child's move. So for those of you who are looking to foster, if a child needs to leave your home for any reason, we first need to get the court's approval to do that. Sometimes we can do brief respites if we need to without court order, but in terms of the court's role, they will be having maybe not a hearing, but they will have to be alerted and approve certain kinds of moves. The other place where the court can get involved and may necessitate a hearing, the court will establish what the visitation schedule is for that child with their birth family and or siblings. So if a child is doing visits and for some reason the visitation schedule that was established is not working and it is a court-ordered visitation schedule, in order to adjust or modify that, the court will need to weigh in. Again, there may or may not be a hearing to make a change to the court-ordered visitation, but it's likely that there will be. So, as a foster family preparing for this process, while we are at this stage in the placement where a child's goal is reunification, where the efforts that are going into that case are primarily looking to get a child safely returned home, you as a foster family can expect that there's going to be pretty regular court appointments that you need to make time to be present at. And unfortunately for you as a foster family, you aren't represented legally in these hearings because you don't have legal standing with the court in terms of having a role legally. You're a caregiver, you have physical custody of the child or children, but the legal process that is occurring is really focused on that child and their biological family. So that's a quick overview of what happens in the child's process. I do want to wrap up by saying that once we reach the point where we, for those of you looking to adopt children out of foster care, once we reach that point where it's determined by a court that a child really cannot safely return home in a reasonable time frame, there will be a goal change hearing. At that hearing, the goal change may be for that child that they are going to move to adoption. And if you're fostering that child and you're interested in becoming a permanency resource, this is an important hearing. This is the time when a judge will decide that it's time to move in a new direction. And this is when we start a process that more actively involves you as a pre-adoptive family. But first, there has to be a goal change hearing, and then there are the steps that start to terminate parental rights for that child. And I'm going to talk separately about the termination of parental rights process in my next video, since that really starts to move into the process for adoption and how that impacts adoptive families. So thank you. Stay tuned for the next video. We're going to talk more about the legal process. Again, I'm Erin Chick with Common Sense Adoption Services. Check us out on our social media and our website. And if you have questions, give us a call.